what I'll do is I'll allow each side to give me a brief opening statement. If you'd like to do that. I know it's a motion for enforcement, and I have reviewed the pleadings prior to coming out. It was one of the reasons it took me a little bit longer to come out. But Ms. Rascala, you may give me an opening statement if you'd like to at this time.
Yes, Judge. Judge, this is an enforcement of the January 5th, 2021 temporary order. The important language from that order is that, I'm paraphrasing, it's outlined in our motion, that Savannah would attend Sylvan. Mrs. Curtis would be ordered to take her to Sylvan according to the schedule determined by Sylvan, and also pay for half of the cost of attendance at Sylvan, and also that order would continue until Savannah was performing at her grade level as determined by Sylvan. There are different indications of whether Savannah is performing at her grade level. One is going to be the Sylvan assessments that are conducted by Sylvan, and the other is the opinion of the professionals at Sylvan, and specifically the owner and director of Sylvan, who is testifying today, Ashish Qatari. Miss Robertson, Ashley Robertson, is no longer at Sylvan, but she testified in the last hearing about a September assessment. I won't get into what the results of that were, but that assessment is what caused the court, as well as Miss Robertson's testimony, to order that, I keep saying the children, but it's just Savannah attend Sylvan. Since that September assessment, there have been a few more, and those the ones that we intend to get into today were performed in January 2021, April 2021, and July 2021. And it is our position that as evidenced by those assessments and those accurate assessments, as well as the opinion of Sylvan, that Savannah is not performing at her grade level. Savannah is about to enter the 4th grade at public school. She was in the 3rd grade last year, and I'll let Mr. Qatari go into what determines whether in the spring of 2021, when most of these assessments were given, if she was at a 3rd grade level, and then as well as whether she was at the proper level for a student in the summer before entering the 4th grade for those July assessments. We also intend to get into a violation pertaining to an unpaid invoice that was furnished to Ms. Curtis from Sylvan in May of 2021. And also testimony and evidence that after May 25th, 2021, Savannah was not taken to Sylvan by Mrs. Curtis, as well as an absence in January 2021. So 1 January absence violation, and then 6 absence violations beginning May 27th, 2021 through June 17th, 2021. That's all I have, Judge.
Thank you. Ms. Daniels, would you like to give your opening at this time, or wait till your case in chief?
I'll give my opening at this time.
All right, you may proceed.
Your Honor, currently the parties are under the temporary order, which is being sought to be enforced today. And under that order, the parties were ordered to enroll Savannah Grace in Sylvan Learning Center. They were also ordered to split the cost, all costs associated, 50-50 split for the cost of the enrollment, as well as ordered to take the child to all recommended tutoring sessions until furthermore, she was ordered to continue to be enrolled in Sylvan until she was performing at her grade level as determined by Sylvan. You will see from the evidence and testimony today that at the time that the alleged violations occurred, she was determined by assessments given by Sylvan, was performing at or above her grade level, thus absolving the parties, Ms. Curtis in particular, of any further obligation under the temporary order to continue to pay any costs associated with the enrollment, with continued enrollment, as well as absolved her of the court-ordered obligation to take the child to any further tutoring sessions.
Okay. Thank you very much. So just so I understand, because it sounds like just from the opening statements, we're going to have assessments that say Savannah was on her grade level, but the experts at Sylvan are going to say, well, that's not accurate. She's not on her grade level. Is that what I'm going to hear, Mr. Scala?
Judge, yes, you're going to hear that most of the assessments found Savannah to be under her grade level. There is a couple on that show that she was at or above her grade level, and our representative from Sylvan will testify as to why those results were inaccurate, and that the determination of Sylvan is still that Savannah at that point in time is not at her grade level, and now is, in need of future enrollment at Sylvan. I think that what you will hear is that the owner of Sylvan saying that the result that was showing Savannah performed very highly above her grade level was an inaccurate result.
Okay. All right. Well, let me look at your motion for enforcement real quick, because I've got something that I think could maybe help everybody out. So on this is just for the lawyers, because I've got a couple of opinions that I'm going to share with y'all, and then let y'all present your cases. But so on paragraph 13, page 6 of the motion for enforcement, it says movement requests that if the court finds any part of the January 5th, 2021 temporary order sought to be enforced is not specific enough to be enforced by contempt, the court may enter a clarification order or an order clarifying the specific duties imposed on respondent and giving respondent a reasonable time in which to comply. So my thoughts are this is a quasi-criminal, filing, asking for someone to be held in contempt. And so in order for me to do that, it's got to be a specific order, and it has to, there's all this case law concerning what that entails. And my thought is, if I've got conflicting evidence, one saying the child is on the grade level, and then other assessments that say the child's not on the grade level, and experts saying that, maybe that assessment wasn't proper, the concern for me is going to be, how do I enforce that when somebody can come in and say, Judge, I have an assessment that says she was on her grade level, and so in compliance with this court order, I didn't have to take her anymore. To me, this is more of a motion to either clarify what was meant by that, or it's a motion to modify to determine whether or not we should continue Savannah continue the requirement and the ordering of both parties to go in and have her continue to receive tutoring from Sylvan. But I'm concerned about the ability to hold somebody in contempt if I'm going to get evidence that there's at least one assessment that says the child is on her grade level. So that's just me thinking out loud. I haven't heard a lick of evidence yet. I'm just going off of opening statements. But to me, it may be an issue where I need to clarify the order, or we may need additional temporary orders to determine, what needs to be done with Savannah. Because if the overwhelming evidence is that she's not on her grade level, but there's one or two assessments that put her on that grade level, well, that's a different burden of proof than a contempt action. And I may find she needs to continue with treatment with Sylvan or tutoring with Sylvan, but that doesn't necessarily mean I can hold someone in contempt for that. So just the that's kind of my knee-jerk response to what I'm hearing. That being said, do y'all want to proceed? Do y'all want time to talk to your clients, or how do you want to do this? I'll start with Ms. Riscala, just based on what you've heard. I haven't heard any evidence yet. I'm just telling you, if I got an assessment that says she's on her grade level, it's going to be very difficult for me to find somebody in contempt of court. But that doesn't mean I won't continue treatment or tutoring at Sylvan. So do you want to talk to Mr. Rayanga and see if y'all want to go forward with the enforcement, or do you want to talk to him about clarifying the order? And then Ms. Daniels, I'll give you the same opportunity to talk to your client. It's really Ms. Riscala's motion, but so it's really her call on what she wants to do. But Ms. Riscala, do you want a second to talk to him, or do y'all want to just proceed?
We actually did talk, me and Ms. Daniels did talk before, and I've talked to Mr. Ranga, and I just don't think that will lead to anything productive today. I think we
Okay.
do need to move forward.
Okay, let's do that then. So Ms. Riscala, you may call your first witness.
Okay, it's Ashish Qatari.
And Mr. Qatari, for the record, if you wouldn't mind just spelling your last name for me.
Sure, it's Kothari, Qatari.
Thank you. Ms. Riscala, you may proceed.
Okay. Good morning, Mr. Qatari. Could you please tell us what you do for a living?
Yes, I'm the owner and director of Sylvan of Sugarland.
Okay, and could you give the address of the Sylvan of Sugarland?
Yes, it's 15219 Southwest Freeway, Sugarland, Texas 77478.
Okay, is Savannah Rayanga enrolled as one of your students?
Yes, she is.
How long has Savannah been a student at Sylvan?
Since last fall of 2020.
Okay. And have you had the opportunity to look at Savannah's Sylvan assessments?
I have.
Okay. What do those assessments show?
The assessments show that initially she was quite far behind, and over time we achieved getting her closer to grade level. In January's progress assessment.
May I interrupt you for a second? I guess what I meant by that is when you talk about Sylvan assessments, what does a Sylvan assessment show what grade level the child is performing at as part of the assessment?
Yes.
It gives an indication of that.
It gives an indication of how the child performs that at that time on the test.
Okay, but specifically about the grade level indication, how is that grade level indication documented on the assessment? Is it a score? What is the rubric?
So the assessment tests the student on metrics for a particular grade level, and based on the result, it gives an estimate as to whether the student has achieved the knowledge that's needed to complete a certain grade level.
Yeah, that grade level. Okay.
So it benefits the student.
Have you had an opportunity to review the assessments that are identified as P3 through P9?
I have.
Okay. I'm going to pull those up and get into each one. Okay, starting with P3. Judge, can I share my screen?
You may. You have permission to do so.
Thank you. Okay. Mr. Qatari, can you see what I've pulled up on my screen here? So it's a Sylvan reading assessment.
Yes.
Okay. What is the date of this assessment?
September 5th, 2020.
And was this Savannah's first assessment at Sylvan?
Your Honor, I object to this line of question as it predates the order that we're seeking to enforce today.
Response, Ms. Riscala?
My response is just to show that the assessments given to Savannah since she's attended Sylvan show her grade level at each point. But I can move on and just get into those that post-date the order for the sake of time, because I'm going to ask
Well,
the same questions.
This was admitted into evidence by agreement, so I'm going to allow you to question just briefly about it, but I agree that we can move on pretty quickly from this point.
Quickly, yes.
Objections overruled.
Okay, Mr. Qatari, what was Savannah's grade level score on this assessment for reading?
2.2.
Okay, and what does 2.2 indicate? Briefly, what does that mean?
It indicates that she is testing at the second grade during the second month.
Okay, so the first number before the decimal is her grade. The second number after the decimal is the month of the school year, correct?
Correct.
Okay. I'd like to ask you some questions about her September 2020 math assessment. What was her grade score on that assessment?
Third grade, second month.
Okay, for either, okay, let me move on. Okay, now I'm going to ask you some questions about Exhibit P4. This is a reading assessment. What was the date of this assessment?
January 16, 2021.
Okay, and what was her grade level score on this assessment?
2.4, second grade, fourth month.
Okay, is 2.4, is a score of 2.4 consistent with her performing at her grade level, or is it below?
It is below.
Okay. And at that time, her grade level was what?
Third grade, fourth month.
Okay. Okay. I'm asking you now about the math assessment. What is on the screen? What is the date of that assessment?
January 16, 2021, and she's at the second grade, ninth month at this point in terms of her assessment.
Okay, is that score at or below her grade level?
It is below her grade level.
Okay, which was also a third grade.
Third grade, fourth month.
Okay. Moving on to Exhibit P5, I'm going to show you a reading assessment. Is this, what is the date of this reading assessment? Would you,
April 17th, 2021.
okay, and what was the grade level equivalent on that assessment?
I think it's 2.1, but your copy is hard to see. Let's see.
Yes, it's,
Yes, 2.1.
yes, yeah, no, you can refer to the paper one that you have that should be marked as well. And is that 2.1 score, January 2021 reading score, at or below grade level?
It is below grade level.
Okay. I'm moving on to P6. This is another assessment from that day, April 17th, 2021. And this is a math assessment, correct?
Correct.
What was the score on that math assessment?
Third grade, ninth month.
And is that math assessment at or below Savannah's grade level?
Slightly above.
Okay. Okay, so that one is just for math though?
Yes.
Okay. There was a reading assessment given that same day, which you testified was at 2.1, correct?
That's right.
So would you agree with me that on April 17th, she was above grade level for math, but below grade level for reading.
That's right.
Would your overall conclusion then be that on that date, she was below her grade level overall?
Yes.
Okay. That same day, was she given another assessment?
She was, the first assessment result shows that she went through the assessment very fast when she did it by herself, resulting in not a clear result for the
Okay.
assessment. And so she was given a second assessment, but the second time she was read to. And so again, we got a skewed result.
Okay, so that second assessment that was given, what subject was that in?
In reading.
Okay. The reading assessment that you just testified was skewed. Did that show that she was above grade level?
It did, well above.
Do you agree that she was well above
No,
grade level? Okay. What are some of the reasons that you don't think that that was an accurate assessment?
just based on her, the teacher's recommendations, seeing the work that she does, the way she tests when she tests on her own versus having the whole test read to her. The teacher, she didn't want to take the test that day, and the teacher helped her through the test, trying to retake it, but she ended up helping too much. So both readings we looked at as just not being accurate enough.
Okay, so when you say the teacher ended up helping too much, could you describe what you think the teacher did and how that may have influenced the score?
She read the questions and answers to her.
Okay. Okay. So there was a much higher likelihood of her getting getting the answers right, in your opinion?
That's correct.
Okay. Moving on to the most recent assessments, I'm going to pull up P7. This is a reading assessment. What was Savannah's score on this assessment?
4.2. So
Okay.
fourth grade, second month. Yeah.
Is that at or above or below her level at that point?
That's slightly above.
Okay. And this is the summer before fourth grade, correct?
Correct.
So you have, what would be your, well, actually, let me get into the next one that I'll ask you. So this is going to be Exhibit P8, a math assessment on 7/15/2021. What was her score on that math assessment?
3.8.
Okay. And that assessment, was she above, below, or at her grade level?
Slightly below.
Okay, so once again, it's a situation in which Savannah is above in one subject but below in another subject, correct?
That's right.
Okay, so overall, would you say that that means that she's at grade level or not at grade level?
She's right around grade level, but not very strong in position. So our hope would be to get her comfortably staying above grade level.
Okay, but when you say right around, it's very important that you be specific. When math is at 3.8, she's below grade level for someone going into fourth grade, right?
Yes. So
Okay.
she's slightly below grade level on math this time and slightly above on reading. Previous time was vice versa.
Okay. When you evaluate Savannah's overall performance at Sylvan, would you say that she is at her grade level as determined by you?
I would say she's approaching grade level.
Okay, could you get into a little bit more specific of what you mean? When you say approaching, I need to know if that means she still has work to do or, I need more specifics on that.
I
Yes.
object. I think this is improper expert testimony. He hasn't been qualified. Mr. Ashish, I'm sorry if I'm mispronouncing your name, has not been qualified as an expert.
Sustained at this time.
Well, Judge, I think that what I'd like to ask him is as determined by him as the owner and director of Sylvan, not as an expert. So I want to know if, as the owner and director of Sylvan, he contends that Savannah is at her reading level or at her grade level.
I still re-urge my objection as to his qualifications to be able to make such assessment.
Yeah, it's going to be sustained at this time. There may be some predicate that you can lay that allows this in, but right now I haven't heard that yet. So the objection is sustained.
So, Mr. Qatari, are you familiar with the way in which the assessments are given to children at Sylvan?
Yes.
So could you describe the manner of those assessments and whether or not you are familiar with how those assessments conclude certain results?
The student is left to take the assessment by themselves. It's a computerized assessment, which gives us this result. So if they take it by themselves, then you should be able to get an accurate reading.
Okay. Have you used this computer program with students at Sylvan?
Yes.
Okay. Have you used this program enough times, and are you familiar enough to know when a student takes a test, whether or not the results of that test are consistent with accuracy, whether they're accurate or not?
Yes, and we use this assessment on every single student, and we use it in order to build a curriculum for that student so that we know what to teach the student.
Okay. So as the owner and director, is it fair to say that there is not any process that Savannah's entered into to yield these results that you yourself personally are not familiar with?
Yes, that's right.
You're familiar with all of this.
Yes, I'm familiar with all of it.
You know how to use it.
This is the core entry point into our program.
Okay. Then I'll ask once again, in your opinion, is Savannah performing at her grade level?
Object to improper expert testimony. The only thing that he can testify to is the assessment, how the assessment works, but the interpretation of the assessment, he does not qualify to make.
I think, oh, sorry.
Yeah, I need to hear, because I know he's testified what 3.8 means, what 4.2 means, but and I know that that's generated, sounds like from a computer program, but I need to know what his familiarity is with that number and what that number means. Like, where did he get that knowledge is what I'm still struggling on. So
Okay.
the objection is still sustained as to predicate.
Okay, let me ask a couple more specific questions. So, Mr. Qatari, can you explain to us how it is that you are familiar with the numerical grade level equivalent on these assessments?
I mean, it's based on the result of taking the assessment. It's not left to interpretation by anybody. It's based on the result of actually taking the assessment and what
Objection non-responsive.
that leaves you.
Overruled. You may continue, sir.
So because it's a computerized assessment, very similar to the Texas STAR assessment, which is what we use. It's a similar assessment. It helps us to create, it helps us to create a curriculum of knowing what to teach, but it also helps us to benchmark the students so we know where they fall in. And our result is usually pretty similar to what would happen if they were to take the real STAR test, which is a benchmark that Texas schools use in order to know where a student falls in.
So let me ask this, is your testimony, your opinion, solely related to the number score that you're getting from that assessment?
It's not just the number score, it's the full report. It tells you the speed that the student is taking at. You get a sense of whether they're guessing at the answers. You get a sense of the confidence level of the student. There are several metrics that the test assesses the student on in order not simply just right or wrong and the number score.
All right, Mr. Scully, you may
Yeah.
continue.
So, and also, would it be fair to say that your knowledge of Savannah specifically has been communicated by you to her parents as well, as far as these assessment results are concerned?
Yes, and I would say also that this assessment.
Objection not responsive.
Sustained after yes.
And is it also your testimony that the parents both have access to these assessment results?
Yes.
Okay. As far as the setup, the business setup of how Savannah was going to be enrolled at Sylvan, could you describe the payment structure that you entered into between Mr. Ranga and Ms. Curtis?
They were splitting the payment on a package of hours.
Okay, so could you describe the packages and how that worked?
So we have two prepay packages to buy a basket of hours. Either you can purchase 100 hours or you can purchase 50 hours. They were purchasing a basket of 50 hours and splitting the payments on those.
Okay, and when you set up the first basket, how was that set up and how was that paid for?
Mr. Ranga paid his share for the first basket of 50 hours. The basket cost $2,500. He paid his $1,250 back when they first enrolled in the fall of 2020. And then
Okay,
Ms. Curtis paid hers afterwards, after the hours, the first part of the basket was exhausted.
okay. Now, could you tell us the price of the first basket for each party?
So it's 2,500 total. Each party owes 1,250. Mr. Ranga paid his 1,250 in the beginning. Ms. Curtis paid hers in February of 2021. And she paid hers in 2 installments.
Okay, and did you have a conversation with Ms. Curtis in the beginning of 2021 about how you would be moving forward with Savannah's enrollment at Sylvan?
Yes, Ms. Curtis.
Okay, go ahead.
Ms. Curtis wasn't very happy in the beginning, but once I was more involved, we talked about how to proceed forward together to benefit the children. And at that time, we set up a.
Objection not responsive.
She needed installment.
Hold on, the objection sustained. You may, he answered it, that it was yes, they did have a discussion. So objection sustained.
Sorry.
Why was Ms. Curtis upset at the beginning of 2021?
Objection to speculation.
Well,
No.
sustained as the form. If you can rephrase that, please.
Did Ms. Curtis tell you why she was upset in the beginning of 2021 with Sylvan?
Objection leading.
Overruled.
She felt that she wasn't getting enough feedback and didn't have a chance to properly be involved, and she wasn't sure of the results of the tutoring.
Okay, was there anything else that she was upset about?
I guess in relation to Ms. Robertson, the previous director.
Okay, what specifically about Ms. Robertson?
I think related.
Objection speculation.
Yeah,
Causes for speculation.
sustained unless Ms. Curtis told him. So if you, I need to know where his information is. So sustained is the form of the question.
Did Ms. Curtis tell you what she was unhappy about as it pertains to Ms. Robertson?
Yes, Ms. Curtis filed a complaint with Sylvan Corporate, so I called her regarding the complaint about Ms. Robertson. So she filed a complaint about Ms. Robertson to Sylvan Corporate. I called her, introduced myself as the owner, told her that I will now manage their enrollment, and got more involved, and then spoke to her about her concerns and why she was upset with Ms. Robertson about her complaint that she had made.
Okay, and Ms. Robertson is no longer working at Sylvan?
That's correct.
Okay, so when you spoke to Ms. Curtis about moving forward Were there also discussions about the schedule that Savannah would be under to attend Sylvan?
Yes,
Okay, what was that schedule?
we agreed upon the schedule of Thursdays and Saturdays, which is what worked best for both parents.
Was that every single Thursday and every single Saturday, Savannah would have to attend Sylvan?
Yes,
Okay, that was the schedule determined by you, correct?
yes, and by both parents.
Okay. And what time was the Thursday and Saturday session supposed to start?
Thursday, 4 p.m. to 6 p.m., Saturday mornings, 10 a.m. to noon.
Okay. And and that was going to be the schedule for 2021, right?
Correct.
Have you had a chance to review your records as to the absences of Savannah from her scheduled sessions at Sylvan?
Yes.
Okay. I'm going to ask you about several dates. I'm going to ask you if those dates you've looked at, if Savannah was absent from Sylvan on those dates.
Okay.
Okay, so was Savannah absent from Sylvan on January 9th, 2021, May 27th, 2021, May 29th, 2021, June 3rd, 2021, June 10th, 2021, June 12th, 2021, and June 17th, 2021?
Yes.
Okay. Did you have a conversation with Miss Curtis about payment for Sylvan after the May 25th, 2021 invoice was given to Miss Curtis?
Yes.
Okay. And I'm showing you a copy of P11. It is that invoice. Actually, here it is. Okay, so the date of this invoice, I think you just said, but just to be clear, is May 25th, 2021.
That's right.
Was this invoice sent by you to Ms. Curtis via email?
Yes.
Would you agree with me the amount was $1,250?
Yes.
Okay. And you have, and you should have with you a copy of P12, what's been pre-marked as P12. Is that document that's in front of you what is that document?
Is it the summer schedule?
No, sorry, I'm referencing the wrong exhibit. Actually, I'm referencing the wrong exhibit because the one that I want to talk about is the one relating to the invoice, and that exhibit is P10. So if you would just go to P10 for me,
Okay.
and I'm going to ask you some questions about P10. So P10, sorry, there's two emails and I keep mixing them up, but P10 is an email. Is this the email that you sent Ms. Curtis, which also had as an attachment the invoice that we just saw?
Yes.
Okay. And what is the date of this email?
May 25th, 2021.
And it was sent to armywife2sgtc@gmail.com. Is that correct?
Yes.
And is that Ms. Curtis's email?
Yes.
And it was sent by you from belair.tx@sylvanlearning.com.
Yes.
Okay, that's the email address you use.
Yes.
Okay. Did Ms. Curtis ever pay that $1,250?
No.
Okay. Did she tell you why she was not going to pay that invoice?
She said that they were done and that she didn't feel the need to continue.
Okay, can you go into more detail about what she told you as far as they being done and they didn't need to continue?
She felt that they had achieved the goal that they wanted to, and they wanted to take the summer off, and she wanted to give the kids time off, and that she would continue on her own, and she would call back if she wanted to continue with us later.
Okay, did she ever say to you that she thought that they were done because Savannah was at her grade level or above her grade level?
No,
Okay, so it was more so about just, were her words to you more so about, in her mind, that she was done with Sylvan?
yes,
Okay. Was it apparent to you from that conversation that her goals for her child were completed at that time?
yes,
Did she correlate, as expressed to you, those goals to any of these assessments that we've talked about today?
no,
Okay. So, in your opinion at that time, and of course, you did not know anything, obviously, about the court order, but in your opinion, did you recommend that Savannah continue to be enrolled at Sylvan past that point?
yes,
Okay. And did you even send Mrs. Curtis a summer schedule that showed the schedule that you wanted Savannah to continue to go by?
yes,
Okay. And you should have P12. What's been pre-marked as P12. Is that document a fair and accurate depiction of the email you sent Ms. Curtis with the summer schedule?
yes.
Okay, I'd like to offer P12.
Any objections to P12?
Yes, improper predicate.
Objections overruled. P12 is admitted.
Mr. Qatari, did Miss Curtis ever bring Savannah to Sylvan on any of the dates contained in that summer schedule?
No,
Has Mr. Rayanga, though, continued to take Savannah to Sylvan in the summer?
yes,
Has Mr. Rayanga told you whether he wants Savannah to continue going to Sylvan?
yes.
Okay, what has Mr. Rayanga expressed to you in terms of his goals for Savannah at Sylvan?
For her to continue through the summer and go along with our recommendation.
Okay, and what other goals?
Well, our recommendation was to hold on to any of the gains that we have achieved, and so to continue over the summer to prevent summer loss. And Mr. Ranga agreed with that and wanted to continue.
Okay, what would, when you say summer loss, what are you describing?
It's common for students to suffer learning loss over the summer because they're out of school and if they're not doing anything. And so our recommendation for Savannah and generally for all students is to continue through the summer in some fashion so that you don't completely lose everything that you've learned during the previous school year, and you can start the next school year stronger and on a good foot.
Okay. At this time, I'd like to pass the witness.
Ms. Daniels, your witness.
Would you pronounce your last name for me, sir? I'm sorry.
Qatari.
Qatari, Mr. Qatari. I just have a couple questions for you. When was the additional 50 hours of tutoring purchased?
The first 50 hours.
Not the first, the additional 50 hours.
Near the end of May.
The end of May?
Well, the first 50 hours were completed in the near the end of May, and the next 50 hours. Well, let me see. I'm sorry. Give me just a moment.
I guess the question is, I guess one way you can think about it is, when were the first 50 hours exhausted?
In April. That's okay.
In April. And do you know when
Yeah.
the recommendation was made, or the more so the purchase was made for the additional 50 hours?
In April.
Okay. The date, do you have an estimated date when you received
Yeah.
payment or invoiced for the 50 hours?
Yes, ma'am. I'm going to give you that right now. So on March 8th, another batch was purchased.
Thank you. So March 8th, was that based on your recommendation? The additional 50 hours
Yes.
based on your recommendation? And what did you base that recommendation on? Because the assessment, you testified, the assessment was, well, it's in evidence that the assessment for April was conducted on April the 17th.
That's right.
So how then was the recommendation for an additional 50 hours made at that time on April 8th?
It was based on the let's see. It was based on the assessment from January.
So the January 16th assessment, correct?
Correct.
So 3 months later, another recommendation without an assessment was made for an additional 50 hours
No, not 3 months later, just 6 or 7 weeks later.
for another 50 hours, correct?
Mhm.
Now, just to reiterate, you are the owner and director of this particular location, correct?
Yes.
Okay, so let's talk about the assessment that took place. Now, before I go there, you mentioned about the packages that you guys offer. You offer a 50-hour package, and there's other alternatives, correct? Outside of the 50-hour package?
Yes.
Is the 50-hour package the largest package that you guys offer?
No.
Okay, so are there any smaller packages that you offer besides the 50-hour package?
Object to relevance.
Overruled.
No, they're not. There's just 2 packages, the 100-hour package and the 50-hour package.
Okay, so let's talk about the April 17th assessment. On exhibit P9, dated July the 13th, okay? It is, I guess I can,
Yeah, let's stop sharing the screen, Ms. Riscala, and then Ms. Daniels, if you need to share the screen, you may as well.
okay, let me,
I'm not saying you have to, but if you want to, you can.
sir, do you have the exhibits in front of you? Okay, so then direct your attention to exhibit P9, okay? And this is the reading assessment, a reading progress assessment, is that correct?
That's right.
And you testify that on July the 13th, Savannah Grace was assessed at performing at a 4.2 grade level, correct?
Yes.
According to this exhibit as well, April 17th, she was performing at a grade level of 6.5. Correct?
Yes.
And that was around the same time. Well, then we'll look at the other right to the left of what we just read. On April 17th, it says that she also performed at a 2.1 assessment, correct?
Right.
Okay, so my question for you is, one, you testified that these assessments are provided to Ms. Curtis in particular, right? That she would have access to this information.
Yes.
And so you would agree that on or about April 17th of 2021, Ms. Curtis received an assessment stating that Savannah Grace performed at a level of 6.5 in reading in April 17th of 2021. Is that correct?
I'm not sure. I can't say that she received it or not.
Would you agree that she had the availability or the ability to receive it or have that information?
Yes, that's right.
Okay. Now I'm just curious about this. Which one of these, you testified to the assessment on April 17th that one was rushed and one was not. Which assessment came first?
The rushed one.
Okay, and what was the score on the rushed one?
Second grade level, below where she even initially was.
Okay, so then the second time that the assessment was administered, she performed at the 6.5 level?
Yes.
Okay. Okay, so then that would mean, and correct me if I'm wrong, that the accurate assessment was that she performed at grade level 6.5.
No.
So it's your testimony that when she rushed, that was the adequate assessment versus when she took her time? Is that your testimony?
She didn't want to take the assessment that day. She rushed.
Objection, non-responsive.
Sustained.
She rushed through it the first time.
Hold on,
Objection, non-responsive. My question to you is
Yeah,
it
the
your
objection is
testimony?
sustained. So, sir, if the objection's sustained, don't continue your answer. Wait for the next question. You
Sorry.
may proceed, Ms. Enos.
My question to you is it your testimony that the accurate assessment is when she rushed versus when she took her time and got 6.5?
No.
Now, you are aware of the fact that, well, I don't know if you are. Let me retract that question. Actually, I'll pass the witness.
Ms. Riscala?
Mr. Qatari, yesterday, did you receive a phone call from Ms. Curtis and her attorney?
Yes.
Did they ask you to provide assessments for Savannah?
Yes.
To your knowledge, prior to that day, yesterday, did Ms. Curtis have copies of her assessments?
I believe she did.
Objection, causes for speculation.
If you know,
Overruled.
if you know.
I know that she had access to ask for them. I don't know if she had them.
Okay. What did Ms. Curtis ever tell you, whether in her conversation yesterday or any point in time, I do not have access or copies of my kid's assessment?
I mean, she does not have access to it. She's always had, everyone always.
Copies or access?
No, I don't know.
Okay, because what the reason, so if Mrs. Curtis's position is that Savannah was at a 6.5, that's why she didn't take her to Sylvan, then would you agree with me? Then
Objection leading.
May I finish my sentence?
Well, the objection is leading sustained.
Okay, Mr. Qatari, do you know if you or anybody at Sylvan, if you know, has had a conversation with Miss Curtis about Savannah being at a 6.5 at any point in time?
Objection leading.
Overruled.
Do you know? Yeah, open-ended.
I don't think so, no.
Okay. Now, a 6.5 is, in your opinion, is that a high score for a kid going into the 4th grade?
Yes.
Does that score mean, in your opinion, that Savannah should be in the middle of the 6th grade?
No.
Okay. In your opinion, is that what the grade equivalent score of 6.5 means? Grade 6, month 5?
No.
Okay. What does it mean then?
I think that both of those assessments were inaccurate.
Okay, then, and I'm sorry if my tone is changing a little bit. Maybe I'm confusing you. What I'm getting at is 6.5 means, agree with me or not, Savannah, that score is a kid in the 6th grade in their 5th month, right? That's what that score means, right?
Yes.
Okay. Now, despite questions about your ability to say, as an expert, if that is the case, is Savannah, is it factual that this kid is going into the 4th grade next year, to your knowledge, right?
Yes.
Okay. So the suggestion, in your opinion, that she is at a 6th grade level is a suggestion that is inflated, in your opinion, right?
Yes.
Okay. You talked about that earlier as being a skewed result, right?
Yes.
and opposing counsel just got into it taking her time being an aspect of that high skewed result, right?
Yes.
Okay. Can you describe for us the exact differences between the 6.5 test that day and the 2.1 test that day, how it was administered and how it led to that result in your opinion?
Yes, the first test, the 2.1 grade level test, was skewed because Savannah went through it very quickly, and it shows that in the test that it was taken very fast. The test times it. The second test, the teacher said that she read it to her and helped her through it because Savannah was crying and in a bad mood. So
Okay.
she helped her through it, but she helped too much. So again, we got a skewed result.
Okay. When that teacher helped Savannah through it and provided answers, in your opinion, is that why she was on a 6th grade reading level in that test?
Yes.
Is Savannah at a 6th grade reading 6th grade level in your opinion?
No, she is not.
Okay. Is there any indication throughout the time between January and where we are now that during the spring of 2021, Savannah was at anything above a grade level for her equivalent in both subjects at the same time?
No,
That's never been the case in spring 2021, right?
that's right.
Okay. And on the dates that you testified to, January 9th, May 27th, May 29th, June 3rd, June 10th, June 12th, June 17th, those dates are within that time frame that your testimony is she's not been at her grade level in both subjects, right?
Correct.
And that is consistent with your opinion, and that is consistent with the assessments that are not skewed,
Right.
correct?
Right.
Okay, pass the witness.
Ms. Daniels?
No further questions.
All right, Ms. Ruscala, any other witnesses you'd like to call?
Yes, Judge, I'd like to testify as to fee, so myself.
All right, you may testify in the narrative.
Okay, Judge, my name is Amy Riscala.
Hold on, before we do that, can we let Mr. Qatari go? Are both sides okay with him being released now?
I may need to call him in rebuttal if they intend to call him in their case.
Okay. All right, sir, just hang tight. You may continue, Ms. Ruscala.
Okay. My name is Amy Riscala. I'm a licensed attorney. I've been licensed since 2013. My firm, not my firm, the firm I work for, the Law Office of John H. Polk, represents Mr. Ray Anga in this enforcement case. In this case, Mr. Ray Anga was charged an hourly rate for my time at $165 an hour and $65 an hour for paralegal time. I believe that rate is reasonable and necessary and customary in cases such as this one. In the month of June 2021, Mr. Ray Anga was invoiced $850 from our office. That invoice is one of the documents contained in P14. In July of 2021, Mr. Ray Anga was billed $1,649.17. And that amount is represented in time reports for the month of July generated by our office. And the time that it took for me to prepare for this.
Your Honor, I
hearing-
object to this exhibit that she's testifying from.
Well,
Well, she's not, it's not, yeah, ma'am, don't testify from the document because it's not in evidence yet. But you may testify as to what you did and what work was done. So as long as are you testifying from a document, Mr. Scala, or from your
Well,
memory?
I would have to use the document to support my testimony, but I'd like to, instead of doing that, because I think it'll take too much time to go through all the entries, I'd like to offer it at the end when I'm done testifying. And then if Ms. Daniels objects, then I guess I could testify at that point more about in detail.
All right, the objection's overruled. You may continue.
Okay. I spent 4 hours yesterday preparing for this hearing, and in that time, I put together exhibits and interviewed Mr. Qatari. He came to my office. We went over exhibits and discussed this hearing. At my hourly rate, that was billed at $165 an hour, that's $660. So prior to the hearing today, based on the time that I've spent on this case, that my office has spent on this case, and which is the work of which is more accurately described in our invoices and time slips, $3,159.14. I'm asking for the court to award those attorney's fees plus my time at this hearing this morning. So 2.5 hours at a rate of 165 in favor of Mr. Ray Enga, whether or not Ms. Curtis is held in contempt. We're asking that those fees be assessed against Ms. Curtis and in favor of Mr. Ray Enga. And I believe that based upon the time and labor required, the novelty and difficulty of the questions involved, and the skill to perform the legal services property, the likelihood which was made apparent to Jake Ranga that the acceptance of this particular employment made a basis of this claim would preclude other employment by the law office of John H. Polk, the fees customarily charged in this locality for similar legal services, for the complexity of the issues raised, argued, and pursued, the time limitations imposed by the client or by these circumstances, the nature and length of the professional relationship with Mr. Ranga, and the experience, reputation, the ability of myself and other lawyers and staff of the law office of John H. Polk. Based upon that, I believe that the fees I just testified to are reasonable and necessary. What I did in connection with this case is captured in the June invoices and the July time slips. But without getting into each billable time entry, because I intend to offer that as an exhibit, I prepared the motion for enforcement. We edited that motion. We talked to Jake on the phone about Savannah. We reviewed the assessments that Jake sent us. We of course did follow up with the court on the filing service of process and preparation for this hearing generally. And we also spoke to Mr. Qatari over the phone, emails, and Jake over the phone and emails, and then finally had a long meeting with Mr. Qatari yesterday at our office. And so I've now testified to all of the documents in P14 except my resume, which I'm also going to offer. And my resume is part of P14. It is my resume. It contains my employment and my education and experience. So as a whole, I'd like to offer all these documents in P14 as a group. So the summary of my testimony as the first page, and then my resume, and then the June invoice from the law office of John H. Polk, and the time slips for July from the law office of John H. Polk.
Are you offering P14 at this time?
Yes.
All right. Any objections to P14, Ms. Daniels?
No objections.
P14 is admitted. Anything further, Ms. Riscala?
No, Judge. We rest.
Well, hold on. You're on the stand still. Ms.
Oh,
Daniels.
as far as my testimony is concerned, no.
Okay. Ms. Daniels, any questions of this witness?
No questions.
All right, Ms. Riscala, you may call your next witness.
Okay, I have no other witnesses, Judge, and we rest.
All right, Ms. Daniels, any witnesses that you'd like to call?
Judge, I'd like to move for judgment. The movement has not, one, identified the respondent on the record. The movement has not identified the order of which the contempt is sought. Additionally, the movement has failed to meet their burden to show for the court to find a contempt on Ms. Curtis. With regards to the claim for attorney's fees, the attorney has failed to meet the requirements under Lodestar, and I don't think she's entitled to, because of that, is entitled to receive an award of attorney's fees.
All right, Ms. Riscala, response?
Well, I can't really respond to the fees because I don't know specifically what was failed on that part. I think that I gave accurate and reasonable and necessary rundown of the fees that were incurred and that are in the invoices. I think that the shorthand rendition of my testimony, as well as my testimony, have like numerical amounts. The reasonable and necessary aspect of the attorney's fees documents was not gotten into in cross-examination. So I testified in that shorthand rendition that I think that they are reasonable and necessary As far as the movement for judgment, I don't think that Miss Curtis needs to be identified. I think it was clear that Mr. Qatari was talking about Miss Curtis the entire time. I don't think there's any issues brought up about mistaken identity or that the person that is the respondent in this case is the person that Mr. Qatari was testifying to. So I don't think that would be necessary. And I also do think that I mean, I could get into the closing argument, but that essentially is my response to this, if I'm allowed to do that.
Okay. All right. Thank you for that. The motion for a directed verdict is denied. We're going to move to closing. Well, I'm sorry, Ms. Daniels, did you have any witnesses you'd like to call?
I do not.
All right, we're going to move to closing arguments. Ms. Ruscala, you may proceed, and then Ms. Daniels, you'll be able to go next.
Okay, Judge, there is no indication anywhere that there is credible evidence that Savannah was performing at or above her grade level throughout the time period of these violations. And of course, the grade level is important because the order says as determined by Sylvan. That determination is captured in the assessments and in Mr. Qatari's opinion. And the evidence showed in every single assessment that this child was at or below her grade level. There was also no evidence to show that Miss Curtis acted out of consideration of the child's grade level when telling Mr. Qatari very plainly that she was not going to be sending her kid to Sylvan anymore because Savannah had met her goal. Mr. Qatari did not testify to Miss Curtis saying anything as far as compliance with the court's order, that Savannah was testing on her grade level. Mr. Qatari does not even have any information through his conversations with Miss Curtis throughout this time that her grade level was ever even discussed, that these assessments were ever even discussed, that these assessments were ever even tendered to her. I believe the testimony supports that Miss Curtis didn't take this kid to Sylvan because she was done paying for Sylvan. She didn't want Savannah to go to Sylvan anymore. Miss Curtis has never wanted this child to go to Sylvan. I do not think she had that 6.5 evaluation in mind because that absurd conclusion would mean that Miss Curtis believed that her child accurately is on a 6th grade level. And I think it is absurd not to put down Savannah, but because any child that tests 2 grade levels above, something like that would be clear as to why that would be if it was an accurate result. So I think the only conclusion the court can reach is that Miss Curtis violated this order willfully. She didn't take Savannah to Sylvan because she didn't want to, and she didn't want to pay for it, which she was ordered to do. And I think that the only thing that the court can do is place Miss Curtis in contempt for her failure to take Savannah to Sylvan. Sorry, not the only thing, because we did plead for that clarification, but something the court certainly can do is to find Miss Curtis in contempt for not taking this kid to Sylvan, resulting in impediments to her continuing to achieve scholastically and just brazenly violating this court's order without any sort of explanation, or she didn't even testify today as to why. And I think we've met that burden beyond a reasonable doubt. I think her actions were willful, as evidenced by the fact that she told Mr. Qatari that Savannah had reached her goals in her mind and no, she's not paying that invoice. Not paying an invoice on May 25th evidences a will to not take Savannah to Sylvan every time after May 25th, as we've pled for. So we are asking for criminal and civil contempt, and we're asking for attorney's fees.
Thank you, Ms. Ruscala. Ms. Daniels?
Yes, Your Honor. This court basically put all of the power in the hands of the folks down at Sylvan to not only tutor Savannah Grace, but also to make assessments that we were going to rely on to determine how these parties would move thereafter. The temporary order that we are here to enforce right now stipulates that Savannah's continued enrollment would be based upon the determination of the folks at Sylvan of whether or not she was performing at grade level. An assessment was made by Sylvan, and Ms. Curtis followed suit in the same consideration that the court placed with Sylvan, and she put credibility to the assessment that she saw. And discontinued because of the assessment said that she was performing at grade level. She discontinued payment according to the temporary order, as well as taking the child to any furthermore or continued tutoring sessions, relying upon the assessment provided by Sylvan according to the court order. Ms. Curtis complied up until that point when she received the invoice on May 25th. Ms. Curtis complied ever since the order was in place from January. She paid her portion. She took the child to every session that she was supposed to take the child to, save and except when she had COVID in January. And so she's been compliant. She's participated.
Object to
What's the objection?
counsel's comment about COVID. That is not in evidence.
Sustained.
She's been complicit. She's participated. She has participated all the way up until the point that an assessment was done showing that this child was performing at grade level, and which was pursuant to the temporary order. There's testimony by Mr. The witness. I'm sorry, I can't think of your name right now. That allegedly Ms. Curtis said that she wasn't going to take Savannah Grace back to, tutoring sessions for some arbitrary reason, but that his testimony is contrary to the reality of the truth, because those statements were not made by Ms. Curtis. So this court cannot find that my client willfully violated the court order. The court cannot find, based on the evidence that was presented, that there was a violation of the court order at all in the existence of the fact that there was an assessment showing that this child was performing at grade level that my client reasonably relied upon, because the court placed Sylvan in the position of being somewhat of the expert or the determining factor with regards to establishing grade level performance. So I'm asking the court that they deny the relief that's requested by the movement and find that Ms. Curtis has not violated this temporary order.
All right, thank you. Thank both lawyers. I'm going to just take a second. Y'all just stay on because it's not going to take me more than 3 or 4 minutes, because I have been reviewing these exhibits as the testimony was being presented. But I want to cut my video, let's just say for 5 minutes. Let me review the exhibits again in detail before I give you my ruling. But I'll be right back with my ruling. If y'all need to go to the restroom or do something like that, just come back in 5 minutes and we'll resume with my ruling at that time. We're going off the record. Okay. Court's back on the record in cause number 18 DCV 256719 in the interest of Ryder Jacob Rayanga and Savannah Grace Rayanga. The court has heard the testimony as well as the argument of counsel, and the court's ruling is as follows. We're going to set entry of this order 2 weeks from today is dead week because we're at advanced family. So why don't we do can we do July 30th? Does that give y'all enough time to get an order together? I don't think the order will be that long.
That works for me, Judge.
Okay, Ms. Riscala, you'll draft the order, and entry will be July 30th at 9 a.m. And the court's ruling is as follows. The motion for enforcement violations 1 through 7, the respondent is found not guilty of those enforcement alleged violations. The court is, though, going to clarify the temporary order to read as follows, because here's the thing. This court was very concerned about Savannah's performance the last hearing that we had. I mean, she hadn't even mastered a lot of the kindergarten elements. And now she's made a lot of progress, even though I know we had a couple of assessments that were off on the reading portion. But regardless of those two assessments that were kind of out of the ordinary, there's been improvement. And that's what we should all want, is improvement so that Savannah gets to the grade level that she wants, so that she is in a position to excel in school. And that was the purpose and the intent of that January 5th, 2021 temporary order, was to get her up to speed. And I'm happy that it appears that's happening, and it's happening at a fairly rapid pace through Sylvan. But I do find that the language of the order, the way it read, was that she needed to continue going to Sylvan until she performed above her grade level, at or above her, until she is performing at her level. And that language, because of those two assessments, the one that they read to her, and then the math assessment was slightly above the level there, a reasonable person could say, well, she's complied with that order the way it read. And so I'm going to clarify the order so that it's clear what is meant by her performing at grade level. I don't want it to be in the hands of and this is no offense to Mr. Qatari, but I don't want it to be in the hands of a person that's in charge of that. I want it to be an objective test that the parties can point to, that can say, look, she's performing at grade level, not an expert that says that. For purposes of my order, it's going to be through Sylvan, and it's going to be through the assessment. But here's the language, and both lawyers, you may want to write this down, because I took some time to try to figure out how to do this in a way that makes sense. And I will say one last thing before I give you my language. Ms. Curtis, I understand, and Mr. Rayanga, I understand that $1,250 is a lot of money. It's a lot of money to me. It's a lot of money to any parent. And I understand that can put you in a financial bind paying for this tutoring. And that was part of the thing that factored into my decision, is I am aware of that. But I also know that my job is to do what's in the best interest of a child. And what's in the best interest of the child is to equip them with the ability to excel in school. And that is what's best for a kid, because educating a child will allow them so many doors to open up for them. And that was the intent of that order. And I understand it's difficult to pay sometimes for additional tutoring with all the other expenses we have going on in life, but she is close to being where she needs to be. I think that if we don't let her fall back during the summer months, we probably are going to be in a position where the next assessment comes in and she's probably going to be performing at grade level. It looks like she's on the path to do that. But this is the way the language is going to read. It is ordered that Savannah Grace Rayanga shall continue to be enrolled at Sylvan Learning until she completes an assessment on her own in both math and reading that establish she is performing at or above her grade level. And I'll put that language in my docket entry. But essentially what I've done is, because of this assessment that was skewed, where we got a 6.5 and we got a 2.1, and I believe she's above a 2.1. I think she probably was having a bad day. We all have those days. And she rushed through her assessment because she just wasn't mentally ready to perform at that level. Because I don't think that based on everything else, all the other exhibits, that the 2.1 was accurate. But also the 6.5 is out of the ordinary as well. And she was helped on that test, at least it was read to her. And so I want her to be able to complete an assessment on her own, which means there's not going to be a teacher reading to her. And if she passes those for both sections, math and reading, where she's above, either at or above her grade level, then the requirement for continued tutoring will end at that point. That doesn't mean, Ms. Curtis or Mr. Rianga, if you want to continue tutoring with Sylvan, that you can. You absolutely can. If you'd like to do that, it's just not going to be ordered by the court at that point. And then hopefully, if this continues, it looks like Savannah is a really bright young girl, and she is learning quickly and getting up to speed quicker than I thought she was going to be up to speed. And so I'm very happy. I know that you're not happy, Mr. Ranga, that I didn't hold her in contempt. Ms. Curtis, I know you're not happy that I'm making you pay more tutoring cost. So both sides are probably going to leave today frustrated, but my focus is on what's best for Savannah. And it appears to me like she's on a good track with Sylvan, that she's very close to being done with it. And I want to get her to the finish line so that she has a successful start to the beginning of the next school year. And that's what my focus is. The request for attorney's fees is denied. That completes the ruling of this court. And we'll set entry, like I said, for July 30th at 9 a.m. And for the ease of the lawyers, I will put the language for the clarification on the docket entry. Thank you all. Lawyers did a very good job, both sides presenting their case. Thank you, Mr. Qatari, for spending time with us this morning. That completes the ruling of the court. We're going off the record. Anything further from either side that I need to address?
No, Judge, thank you. Will the July 30th be an oral Zoom entry hearing or, okay?
Yeah, it'll be by Zoom. And if y'all
Okay.
submit the order and it's just signed by both lawyers, not saying they agree with what I said, but that both lawyers agree that that was the order of the court, nobody needs to appear on the 30th. I'll sign it as soon as I get it. So if y'all can get that in before the 30th, nobody will need to appear for entry.
Okay.